is the Family Law Channel. The Supreme Court has ruled that guards may routinely strip search even minor traffic offenders when they are arrested and detained. This was a narrow ruling coming in the case of a New Jersey man who was arrested because of a computer error. He was stopped for unpaid traffic tickets and was jailed for 7 days. My guest is the retired Superior Court judge from Santa Clara, California. You know him, you love him, you can't live without him, Judge Eugene Hyman. Hi, Judge.
How you doing?
I'm doing great. Better than Albert Florence was doing when he was stopped. So Albert, his wife, and his little boy were on their way to their parents' house. This happened back in 2005. They were pulled over by a state trooper. Mrs. Florence was actually driving, but the trooper's roadside state records checked showed that there was a 7-year-old outstanding arrest warrant for Albert for failing to pay a fine, which he had actually paid, which he actually had the receipt in his car for just these kinds of circumstances, yet the trooper said, "I have no recourse here other than to take you in." And he, for some reason, was jailed and strip searched for 7 days. How do you explain that?
Well, I can tell you that in California that probably wouldn't have happened because given the premium on jail space for these kinds of minor offenses, the people receive traffic citations giving them a date to appear, and they're not even taken down to the station. Hypothetically, if they were to be taken down to the station, they would have been initially held with the idea that someone hopefully would come down and post bail, actually pay cash, and then the person would not have been actually booked into the main jail system. Most jails have a procedure, a policy in terms of where they keep people that are temporarily detained versus those that are actually booked into the jail and become part of the general population. Those that are detained, sometimes referred to fishbowl, they aren't strip searched because they don't actually go into the main jail. They don't actually become part of the main population. But once someone becomes part of the main population, then they go through a detailed strip search, which is what happened to the defendant in this case. Now, what compounds what happened to the defendant in this case, the fact that he was taken to the county jail where the traffic stop took place, which was not the county that held the warrant. So they held him for probably a couple of days, and then he was then transferred to the county that actually held the warrant. So when he left the County A and went to County B, he became part of the population of County B, and when they accepted him, they strip searched him again. So he was strip searched twice.
Well, Judge, given this example here and this event, why did this happen?
What I'm unable to tell, having read the case, and there are two issues here. The issue before the United States Supreme Court only had to do with the strip search and with respect to his civil suit as a result of the strip searching, and he was suing on federal grounds, civil rights violation for the strip search. What I can't tell from the case is whether he also had a state case going for false arrest and false imprisonment because the arrest warrant was wrongfully in the system and had not been taken out when he had taken care of it. So there's two separate issues here, and I just don't know about the other potential case that might be out there.
Well, let's talk about Justice Breyer and Justice Kennedy and what they said. Justice Breyer noted that people who've been detained in strip searches for minor offenses, like having a tail light or a headlight that's out, a traffic violation, typically aren't expecting to be arrested, so they aren't likely to have hidden some sort of weapon. Now, what Kennedy said was that, given the fact that there are 13 million people arrested in this country, we can't isolate one group because it would be impossible. What do you say to that?
Well, that's a tough one. I'm inclined to agree. I mean, it depends upon what we're talking about. If we're talking about drug possession, I absolutely agree with him. Given the numbers of people that use drugs, possess drugs, things of that nature, he's reasonably correct in the sense that there are people that are going to be possessing substances, whether they're arrested for a traffic light out or whether they're arrested for armed robbery. If we're talking about weapons, however, then I would disagree. I would think that the average person statistically who is going to be stopped for a headlight out or something like that probably, as a general rule, isn't dangerous unless they're stopped for that and they just completed a robbery 2 seconds ago. But one of the things that Justice Breyer was saying is that if you look at studies in terms of overall, you might, the person with the drugs might be there, but the person with the weapons aren't. But then what Justice Kennedy's position and the position of the majority would be, they're not going to take a chance. All it takes is just one. This reminds me of a case that I had in juvenile many years ago, where a police officer approached a bunch of juveniles and he thought that they were violating curfew. Not curfew, truancy, that they were hanging out school. Actually, every one of these kids had left school early except for one. And this one kid got nervous, and he started sticking his hands in his pockets and things like that. But the officer asked him to remove his hands and then did an outside the garment pat down on him. And based upon the officer's experience, he determined that the guy had a rock of meth and ultimately removed it from his pocket, and sure enough, that's what it was. And so the case came in front of me for search and seizure, a Fourth Amendment allegation, and I denied the motion. And the juvenile took that up to the appellate court. And the appellate court reversed me, saying that not every teenager who is nervous has a weapon in his pocket. And my response was, hey, all it takes is once for some kid to go, whether it be a gun or a knife or even a hypodermic, to stab someone, and that's all it takes. So if you want to take that argument forward, then yes, it would be appropriate to strip search anyone. Certainly anyone that goes to the general population, I agree, needs to be searched thoroughly.
Okay.
But I would question whether or not they need to go into the general population for a minor offense.
Well, it sounds like I'm thinking that this kind of case could come up to the Supreme Court again.
Oh, absolutely. And Justice Kennedy and the majority suggested that they wanted to send a message out there to law enforcement and to county jails that they were ruling narrowly on this particular case, but that they could foresee where case with certain kinds of facts could appear in front of them, and they would rule differently. The other issue that not discussed in this particular case, but an inference certainly, is that there's a difference between strip searching and then checking body cavity.
Right.
Body cavity searches are going to require, based on case law, a heightened suspicion. You just can't prophylactically body cavity search everyone. You're going to have a reasonable reason to think that there's contraband. And don't misunderstand me, there are circumstances where people put drugs in body cavities.
Right.
And there's also circumstances where people put guns in body cavities. But in order to have that kind of an extreme search, you're going to need some kind of probable cause to believe it. And even then, you're going to have to take the person to a hospital. Not someone who's medically trained is going to have to do the examination, unless, again, you can demonstrate exigent circumstances in some way in terms of justifying someone, a non-medical person, doing search.
Well, once again, we appreciate your expertise in this area.
Thank you.
This has been the Family Law Channel. My guest, Judge Eugene Hyman. I'm Scott Drake. Thanks for watching.